we release victims back to their countries through repatriation. This is because we lack shelter houses or safe houses. As we are aware, the government does not have a shelter run by the government. We've been depending on the NGOs, such as HEART, sometimes Salvation Army. And that is why you find that most victims are held at police stations. And then the police are also saying the human rights, they call them the human rights people will catch up with us. We cannot keep them here. So what do we do with these witnesses? Sometimes the investigation does not reveal who are the perpetrators. In that case, the witnesses will be repatriated. Unfortunately, some of them are charged for being in Kenya illegally. Something we are being advocating for and creating awareness to the police and even to the prosecutors that victims are not supposed to be charged. They are not supposed to be charged for being in Kenya illegally or where they commit a crime in the process. They should be given an immunity in that regard.
And then we're also going out of our way to approximate.
Lastly, I want to talk about the progress that we are making as ODPP to enable these cases prosecuted successfully. We are encouraging plea bargain and diversion as an alternative to prosecution, and also tracing of the main perpetrators, because this complex crime cannot just be investigated successfully without plea bargaining with the actors who played less role. So through these actors who played less role, they help us trace the main perpetrators, and that is why we're encouraging plea bargain and diversion. For now, I will stop at that, unless you have a question, Juliet.
Thank you very much, Evelyn. And actually, you've highlighted or sort of preempted some of the things I want us to focus on a little bit later. But thank you for also mentioning some of the challenges that you have experienced in your work as prosecution. And but we'll be coming to the issue of plea bargaining and. So we want to see how are these sort of policies and practices harmonized. But I will come back to that. I just want to in Kenya, what has been your experience when it comes to cases?
First and foremost, I'm very grateful for this opportunity, and even having the opportunity to speak more about the role of NHRIs or the role of national human rights institutions when it comes to supporting fight against human trafficking. Oftentimes, there is a perspective that victims of trafficking who are in the criminal justice system. So I am glad about the work of Kenya National Commission on Human Rights. And what we have, then they'll come in and they'll say their children have been stuck in a foreign country because they went in to seek either better education or even different ways. Some of them are for adventure. So when this has then from that point, maybe human rights violations patterns that are to another organization. So oftentimes we've had to refer cases, of course, to the anti-trafficking for adults, but beyond that, we have also been able to liaise with counter-trafficking in persons and Secretariat, and also CSOs. And the reason why I bring the CSOs, it depends. At the point of evaluating this particular case, you look at a case and you realize at this particular point, you want this person to be rescued. You want this person to be identified where they are and to be rescued, because you cannot have prosecution if you do not first look at the interests of the victim. So oftentimes we'll then look at what do we need to do. Is it a matter of referral? Then we undertake that referral. Is it an issue that we as a commission require to liaise with the Ministry of Foreign Affairs? And again, this is because it's a policy. As a commission, our mandate is only restricted with the different consulates to reach out to different persons. Prosecution of that particular case. But in reality, apart from just looking at the victim cases which are presented to the Kenya National Commission on Human Rights, where they have seen or where they have found challenges with ongoing court cases. And I'll give an example. That then would support the success. On this other side, you also have the counter-trafficking in persons Secretariat coming in again, because they are the duty bearer when it comes to ensuring that the victims of trafficking are properly assisted. So we had a number of course, we had a number of organizations involved in that particular case. And here the intention was, number one, for us as a commission, when we came in, we were looking at what is the best thing for the victims. If we have increasing risk, that really was required, but I'm happy to report that through the engagement of all these different actors, we were able at least to reach a consent that was registered in court, and it brought about the safeguarding of the rights of these victims, who are then later on, they were repatriated to their respective countries. Are the cases still in court? Of course, the case is still in court. So all I would want to say for us as a commission, and even call upon the other NHRIs, one of the key areas they can easily come in to support prosecution. By virtue of us not being the frontliners, we are not the police in terms of the investigators, neither are we the prosecution, who of course are very keen on the prosecution processes, neither are we the judicial officers who then take care of the presiding upon a case. And neither are we the prison officers who then take care of the persons who've been convicted. So as NHRIs, our role is cut out. Our role ideally should be to focus on how we can keep on reiterating to the system, to the criminal justice system, on matters of trafficking in persons, on the need to uphold the rights of the victims of trafficking. Because we have had situations where the victims have been penalized in the same process. And I would also go back to the fact that apart from just supporting individual cases that are either reported to us, as a commission, we have the mandate to identify areas where we have systemic human rights violations, undertake evidence-based research, which then can be used to advocate for policy reforms. And a good example would be some work we've been doing for the last 1.5 years. We set out to undertake a study of the status of foreign migrants in our detention places and other holding facilities. A key aim of this study was, number one, to try and address the gap that we have always had, victims being penalized. And my colleague Evelyn has already spoken to the fact that oftentimes you have some of these cases which are taken to court for trafficking in persons. You have situations where we have had victims being presented in court and not the trafficker. We also have cases, and I think my colleague Mweni will also attest to that we have had cases where the persons who are arrested and who are then taken to the court process and charged with unlawful or illegal entry into Kenya are victims of trafficking. But because somebody somewhere was not so keen on doing thorough investigation, they looked for an easier way, then the victim ends up being taken back to the court, to being criminalized in the process. So what we call double jeopardy. So as a commission, we noted that there was this gap, or we continue to have a gap on how best can we support the fight against human trafficking, and how best can we safeguard the rights of migrants, including the victims of trafficking. So in this particular case, I would say we set out to do this study. The study focused on these particular places of detention. We sampled the prisons, 55 prisons to be precise. We were also able to sample 120 police stations. We also sampled five border posts and sampled 130 children institutions. For children institutions, we focused on both private and the government statutory institutions. So these are institutions which are either managed by Child Welfare Society of Kenya or the Department of Children's Services. But also we were able to sample the charitable children institutions. Why did we go that way? Because oftentimes the children who are migrants, and the majority of them are victims of trafficking, are lost in that process. So in other words, what I would really want to say, the study here was just one way of us as Kenya National Commission Human Rights looking at systemic gaps that we have in migration management, picking up that area, undertaking a research to inform policy decisions or policy advocacy based on evidence that has come up in the research. It is interesting for my colleagues here who are of course from our neighboring country to state that one of the findings we made is that 70, say how many? Let me just look at this. One of the findings we had that was very interesting is that the majority of the migrants then in our detention places were Ugandans. And I think also my colleague, the moderator here, Juliet, spoke about that, alluded to the fact that one of the main cases we have the number of girls who had been trafficked. So again, the need for us to really go back and address this. So with that, I would just say, of course, we receive cases, we undertake research to inform evidence-based policy reforms. We also keep on interacting and building partnerships with different actors, again, to allow the communities to appreciate how they can support their fight against human trafficking. Thank you so much.
Thank you very much, Veronica, and thank you for elaborating for us your role as NHRIs, and also actually the wonderful call to action to other NHRIs to support victims and support prosecution. You of course highlight particular issues that I also want us to bring to discuss after after everybody has had a chance to present, and the question of having victims of trafficking as perpetrators or offenders, and how, one of the things I want us to start thinking about, actually, all our panelists, is how do we decriminalize victims of trafficking, because they find themselves on the wrong side of the law for various things and for various reasons. But how is it that we start supporting them in our various roles to make sure that we decriminalize any criminality that can come out of their situation? And allow me now to invite, oh wow, she just left. I was going to invite Madam Rachel because I wanted to, well, she's here. Good afternoon, Rachel. Happy to have you here. I want to ask you, you've heard, what are sort of the NHRI in Kenya has said. You've heard what Madam Evelyn has said from the side of DPP in Kenya. I want to hear your view. I want to there is anything that your office has been able to do since this particular rescue. We are looking at 96 Ugandan females, 96 Ugandan females who were actually rescued at JKIA, and Africa to help.
Good afternoon, everyone. I'm glad to be here this afternoon. Like you've already heard from the unit in the ODPP's office. So thank you very much, Evelyn and Veronica, for your insights about trafficking in Kenya. What takes place in Kenya is not any different from Uganda. Good cooperation and collaboration in our efforts to combat trafficking. Not long ago, we heard about also rescued from Kenya and returned to Uganda. So, Ruth, you asked me what we have done about these victims. What I can tell you is that since the enactment of the Prevention of Trafficking in Persons Act, that is the main legislation that handles trafficking, we have seen an increase in. Am I clear?
Yes, you are. Yes, you are.
Okay. Well, we have seen an increase in the victim-centeredness of the rescued girls and boys. The task force, my informed and victim-centered approach for engaging trafficking victims. So since this Trafficking Act came into effect, we have seen several civil society organizations empowering countless victims, survivors to build their lives and play a meaningful role in bringing their traffickers to justice. So between us and Kenya, we have registered several bilateral meetings aimed at strengthening the border controls, border control measures. And it's as a result of this that we find that these victims were rescued some of them repatriated back to Uganda. Well, we have initiated investigations into the matter. We have not yet prosecuted any of the traffickers in the case, but what I can confirm with certainty is that the victims were sheltered by the various civil society organizations. They received the necessary psychosocial support, and some of them have been reintegrated back in society. But this does not mean that we have stopped our case investigations in the case. We believe that there's a network that is operating between the Karamoja area and aimed at trafficking vulnerable girls from Karamoja to Nairobi. And then also we had some from the 96 from Burundi. So this is what we are still investigating to get to the actual traffickers. And between Kenya and Uganda, we have also seen joint trainings, and all these. And of course, besides the successful, then our investigations will be swift, they will be cheaper, and will be more effective and efficient. And we and besides that, we have also have what we call the East African Association of Prosecutors, and this is what brings together prosecutors to cut down on some of the bureaucratic processes that would be involved in otherwise getting the official transmission of documentation, of evidence, and all that. So once we use this trust for information, and from that information, that is when we take action. And that's when most of the rescues have taken place. But besides this East African platform for prosecutors, we also have the mutual legal assistance. Feedback, and we have progress. We have registered progress in those cases, and so on. So what am I? Because there's a case that we jointly investigated in Rwanda, and exploitation. So, investigative team, in as far as relocating the victims who are in Rwanda, and once the girls who are in Uganda had reported the case to police, and when we made a follow up, we conducted what we conducted prosecution-led investigations in the case together with police. Burundi. We even had to take the case, this particular case. I think the accused was called Omotoni Annette. So with this particular case, we charged her with aggravated trafficking. We did not get other aggravated trafficking, and protection for the victims because they are really under threat, as this woman was citing political influence. That in such cases you need to get the consent of the Attorney General, but in this particular case we only got the consent of the DPP. So when we reached court after we had closed our case, it was challenged that we did not get the consent of the Attorney General before instituting the proceedings. So the case was dismissed at the case, and this meant recalling the case. But well, that at appeal. So because it's a bit new, we prosecutors in traffic a lot to do when it comes to sensitization, because most of the prosecutors and the investigators are familiar with the Penal Code, Act, as opposed to sexual exploitation. So it is what we are embarking on.
Sort of tell us how that works. But I want to invite Madam to carry out investigations. Share with us your experience when it comes to human trafficking cases within East Africa. I know, and not just East Africa, probably even across the board, and what it is that you have seen. And what are some of those challenges that you're facing when it comes to investigations and getting clear evidence? Karibu.
Thank you very much, Madam Ruth. It's a pleasure to be on this platform today. My name is Moening Patricia. I'm working for the DCI Anti-Human Trafficking and Child Protection Unit. And what I would say is we usually deal with both online and offline. And in most cases, you find that we apply as a unit, usually use intelligence-led state and non-state actors. These are, and in fact, the publics. These are the people that have made it much more easy when we get this intelligence. Ground check again, and so you find that required evidence. We're supposed to make sure that our evidence is possible to support the crime of trafficking. And even when we're seeing, like in the case of smuggling, human smuggling, we don't just treat it as smuggling. Why? Because most of it is very easy, and especially for police officers. Why? Because of the complexity of the crime. As alluded earlier by the previous speakers, they've said that trafficking is usually a complex crime. Why? Because of the processes that are involved. That is the act itself, the means, and the purpose of the offense. So you find that the DCI and the Human Trafficking and Child Protection Unit trafficking. It has received specialized training from again forwarded to prosecution. So if I would say some of the challenges that usually encounter we are able to identify a victim. We are able to treat a is going to be treated as a part. Veronica or someone that said that in most cases you find that we commend or we even state that this person has been in the country illegally. Why? Because the capacity to prove that crime is a challenge. It's a gap that has been in most of outside police stations, especially where we do not have specialized units that are dealing with this crime, that is a trafficking crime. So in matters of dealing with the victim, you find that the perpetrators of that criminal victims because we've got limited shelters. Of the different stakeholders. You'll find that there's that person that wants to, like there's an organization. So in this case, there's that push to get into the rescue process without even carrying when that is that challenge of conflicting interest from the different stakeholders. And then another challenge that you've got is facilitating witnesses to the suspects that were held back. And there was an agreement between ourselves and the Ugandan counterparts that the victims will be, the witnesses will be end of the day, what would the cost do? The day it is to throw out the In that particular case, this suspect was repatriated back to Uganda. So now you see the challenge of facilitating witnesses to appear when the proceedings are ongoing. And then we've got another challenge whereby you find that the referral mechanisms are not clear. Find that there's certain situations whereby we are told by the courts that we need to reunite the children or the victims to their families. So in this particular case, I think it would be necessary to come up with referral mechanisms that are very clear, like who is going to carry out the process and who does 1, 2, 3, 4. So another challenge that I would say is the application or the implementation of the Counter Trafficking in Persons Act 2010. We've got a challenge with Section 4, subsection 1 and 2. So you find that in most of the times, as we have to prove beyond reasonable doubt that the process of fostering, the process of guardianship, the process of adoption was not for the purpose of trafficking. And not unless you find the specialized unit of the trafficking, the TOCU unit and the anti-human trafficking child protection unit, not unless you find that the persons that are bringing in these cases are from this specialized unit. If it's going to be any other person, it will be a dealing with the
victim, the psychosocial aspect of the victim will be covered there. And the issue of victims' rights during the trial process. Who really is responsible here? And I'm asking Evelyn and Veronica as well. When it comes to our laws, I know in Kenya and in Uganda, I have including restitution, including rehabilitation, including rescue, and all the support that they should get, including legal assistance in cases. So who is supposed to take think they could do a good job. And especially when we're looking at victims across border, we have victims in Kenya from Tanzania, we have victims in Uganda from Burundi and Rwanda as well. really where is our role, and who is really responsible for them. And then of course I will ask Rachel to come back in and sort of explain to us what the mutual legal assistance and other frameworks that exist in between for us to be able to carry out proper prosecutions, and also Evelyn could tell us the role of plea bargaining. Is this the end? Is it a means to an end, especially when it comes to victim support? And by victim support, I mean in terms of the restitution, because some of our laws say that. And yes, so feel free to just jump in. I think I will give a chance to Veronica, first of all, to start us off. Karibu.
Thank you, Juliet, and thank you to my fellow panelists. Very insightful, but also informative discussion. On the question on who is responsible for the victims, I would want to first go back to our Counter-Trafficking in Persons Act here in Kenya. That particular law is very clear on the institutions that have been established to address the different assistance that is required towards supporting the government of Kenya in addressing counter-trafficking in persons cases, not just the programming on counter-trafficking in persons, which is then required to advise the minister responsible the advisory role given to the advisory committee, which I am part of, is to advise on how to handle pathway and partnership that then will help us to understand if there is this particular case of a victim that has of this particular on what are some Act. In Kenya alone, we have the Victims Protections Act. This Victim Protection Act, again, is a law that they require. These victims are this particular act that looks at different victims. What I would say to answer that question briefly. And this government has delegated that responsibility to different institutions which have been established within the Counter-Trafficking in Persons Act.
Thank you very much, Veronica. Evelyn, plea bargaining. Is it the end? And
let me just add my voice talked about. I usually say that presumption of victimhood way as the presumption of innocence is key to the protection and this law enhances the role played by the victims at plea stage, bail hearing, submission, and during sentencing. And how do victims give their voice or present their case to court? Sometimes they are not represented. Sometimes they are represented. So the law allows whether this accused person should be released on bail or when coming up with appropriate sentence. So it is a state obligation to protect victims as part of their international obligation for purposes of upholding human rights. Thank you. Now let me touch on plea bargain. Plea bargain generally is a negotiation between the prosecutor, the accused person, or his advocate. In cases where accused persons agree to plead guilty or not to contest to some of the crimes, in return for a reduction of the severity of the charge, or the state may want to reduce some of the charges or drop some of the charges, and the state will also propose to recommend a particular sentence or some other benefits to the accused person. So it is generally an agreement and a negotiation between accused person and the state. This agreement can be initiated by either party. It can be by the accused person or the prosecutor. So this the plea bargain is governed under legislative framework under Article 157(9) of the Constitution. It gives us prosecution. DPP could enter, could find can reject the plea bargain recognized under Article 159(2) of the Constitution. Again, there is an Act number 3 of introduce an amendment to the CPC and introduce Section 137A to 137O. So this is where plea bargain is outlined in the CPC. Plea bargain rules. So these are the rules governing the plea bargain. And if I may talk about the advantages of plea bargain. Plea bargain has a lot of advantages to both the prosecution, to the court, and even to the witnesses and the accused person. First of all, it reduces time. As we know very well, cases may take forever in court. This time is reduced. And again, the court considers when accused persons agree to plea bargain, the court, while giving sentence, will consider that the accused person did not waste the court's time in writing judgments, calling witnesses, and all that procedure. So it saves time. Again, there is a definite that we are sure that the accused person will be convicted. We are sure of conviction. We are sure of conviction. Because when the accused person agrees that he did it, definitely the court will punish him for the offense committed. Thirdly, even to the accused persons, when an accused person them that indeed justice is being done. Again, to court, it reduces backlog. We see there are a number of cases. Trafficking cases are not specialized. We don't have specialized courts. We don't have specialized magistrates. So they are not heard on priority basis. And as you are aware, witnesses tend to get tired. They tend to tire from court, attending court, being taken through their statement now and again. So plea bargain saves us from all this. Just to report, the DPP has done a milestone in plea bargaining with the accused persons, mostly in anti-corruption cases. We have, let me just take you through the cases that we've had successful.
Maybe Evelyn, I can look through the cases.
Yeah.
Yeah, you could tell us, what do you think that it's a successful? I mean, would be a way to go. Would you encourage other prosecutors to pursue with the advocates of accused persons in cases of human trafficking to, pursue plea bargain?
I would definitely encourage plea bargain, and I would definitely encourage our prosecutors and even investigators when at investigation stage, when they know that the kingpin cannot be traced or arrested, they can even give the other accused persons who've been arrested an immunity to even help them trace this person or promise them that they'll not be prosecuted, such that these people who are behind these crimes are prosecuted. Again, to get only the victims, they are still proceeding. They mutate. They go to other countries and do the same. They look for other victims. But the moment you touch their finances, that is when they'll be shaken. So this is why.
Sorry to cut you short, but thank you very much. And I'm happy with what you're starting to say now about finances. We'll have a breakout session. Please carry on that discussion there. I just want to invite Madam Rachel to just tell us about the bilateral frameworks that exist in between countries in a bit more, simpler language so that we can all get to understand what you mean when you say mutual legal assistance. Thank you very much. Maybe in 2 minutes. Thank you.
Okay, thank you, Ruth. So when I talk about mutual legal assistance, well, basically it's in criminal matters, it's a process by which states seek for assistance and provide assistance to other states in the gathering of evidence, exchanging of information, in an effort to enforce a criminal matter or a criminal case. So usually when we talk about mutual legal assistance, it's commonly used to interrogate suspects in a criminal matter when the suspect resides in a foreign country, or if not that, when there is need for extradition. I have if I have a case in Uganda and the trafficker is in Nairobi, so our central authority would be the Ministry of the Attorney General's office. So the office of the DPP is the competent authority. They will generate the formal request, send it to the central authority, which is the Attorney General of Uganda, and then the Attorney General will send it to the Attorney General in Kenya. But like I said, that there's no standard procedure. Usually what we do as because of the collaboration and the coordination we enjoy between East African countries. So by the time I even send a formal request, I have already made an informal request to maybe my colleague in Nairobi or Rwanda, and I've already briefed them about the intending case I have, or the evidence I need, or if there's a suspect I need to be extradited. So by the time the formal request comes through, so the process is quicker because my counterpart is already aware of the matter. You understand? So, but when we are making the application to the central authority, so the requesting authority, which is Uganda, should indicate the case reference, the summary of the facts, the evidence. We attach the necessary documents like the charge sheets, the warrant of arrest, if there is any affidavit from the IO, if there is any photos, any kind of evidence, such that to prove that actually the case is credible and has merit, and there's actually need for you to provide me with evidence or to have the perpetrator extradited. However, I should say that in Uganda, we do not have this MLA Act, but because we are a member of the Commonwealth, so the Commonwealth scheme on mutual legal assistance exhibits, you understand? So the reason why we insist on having a mutual legal assistance, because then it helps us to get credible evidence to maintain the integrity of the evidence, to follow all the procedures such that MLA, which we have a formal procedure of requesting for evidence or information or whatever it is. But also it comes with some challenges. Like we all know that investigations across the border is very costly and risky. And then the issues of funding of a joint investigation team is also challenging, as well as prioritizing the we are sending this request to a country that has no the whole procedure. You send it to the central authority, which is the Attorney General. You send it to maybe Kenya, to their competent central authority. Then they trickle it down to the central authority. So that can take really, it derails the investigations probably, and we may lose evidence in the process. So that's why usually we prefer first having the so probably you also wanted me to look at the other mechanisms in international crimes that can help police chief corporation, that's the YAPCO. The formal procedures of MLA. And even the forum for prosecutors, like I said, the informal one is really fast. So yeah. So besides the YAPCO and the cooperation of the East African Association of Prosecutors, which I really find to be very true, you have a response, you know, and then you initiate the hormone. This is also one of the other mechanisms that we use in getting this
Thank you for highlighting the various frameworks and also explaining in detail about the mutual legal assistance. And I am very happy to see the kind of collaboration that is happening that we'll have two breakout sessions. One is breakout sessions, and you'll be able to have much more information, and I'm sure Madam Weni, allow me to come to you. We struggle to understand their position and how we as I'm seated at the bus station, and I know that there's a them or call Interpol in Rwanda or in Burundi or in Uganda or Tanzania. How do you collaborate with them to combat human trafficking? Madam Weni.
When it comes to thing that I'll not talk about all the notices here, but they've got certain notices. For example, a case of traffic alert is placed through to all these other countries where the suspect is, and it's possible to identify victims of trafficking or victims of sexual exploitations and such.
Thank you. So, do I, me as a person who wants to report a case of
you don't need to report to Interpol. You can go straight to the nearest police station, the DCI Anti-Human Trafficking and Child Protection Unit. You're going to find that between the two units, we have the TOCU and we have the DCI Anti-Human Trafficking Child Protection Unit. So the TOCU deals with trafficking of adults, and the DCI Child Protection Unit deals with the for children, that is the DCI Anti-Human Trafficking and Child Protection Unit. We can also report straight to the DCI. We've got the platforms, we've got the social.
I think this has been one of I just want to thank all my panelists. Unfortunately, one of us was not able to join in. Hopefully, you can catch him on. Plea bargaining is a way to go. It's a and also because it quickens up the cases, so there is no backlog so much. So it's beneficial to all parties. The MLA, mutual legal assistance and other frameworks, letters. Traffic, we can prosecute these traffickers. And finally, time for us to start looking at where and tracing the.
Juliet, as usual, brilliant work. Is going to go past this platform. As you can see, as I said earlier, for those ones who are late joining in, it's a new platform, but breakaway sessions. So on your left, I hope so, on your left, you will see session and it's written up, it's written now. So the moderators have already joined in. So the session to join one of the panel to click on to join that one right now, because that one we're going to use it for the last plenary, because we cannot be able to add any more speakers on this particular platform, this particular stage. So we have moved that, as any other meeting, we always move things from one room to the other. So we have moved the last plenary to session. You see it is written panel 3. So for that, please, you can start moving now, and you have the